So, welcome to the third seminar in our new online lecture series on resource struggles and international law under occupation, convened by myself, Julia Dam, and my colleagues Sahiba Makwal and Caitlin Murphy. Before introducing our speaker, we want to acknowledge that we're joining the seminar from occupied lands and that struggles for land justice, for water justice, and resource justice continue across this continent. We want to acknowledge the Wurundjeri people of the Kulin Nations as the traditional owners of the land on which we're joining the call, that their land was stolen and that their sovereignty was never ceded. We pay our respects to their elders past and present.
The online lecture series seeks to foster interdisciplinary and historically inflected discussions about how international law both shapes and is shaped by struggles over natural resources. In semester 2, the lecture series will focus on resource struggles in the context of occupation around the world. We will collectively explore how struggles over resource plunder and exploitation shape the dynamics of occupation and how people under occupation are contesting extraction and asserting ownership and sovereignty over resources as part of broader resistance movements. Speakers will examine resource struggles under occupation in Greenland, West Papua, Palestine, Kashmir, Bougainville, and Western Sahara to consider the different forms of political contestation they produce and how resource struggles might be mobilized to enliven political possibilities for self-determination and decolonization.
So we're really delighted to have such a wonderful lineup of speakers for this semester, as well as Professor Michael Lynk, who we're really thrilled to hear from today. We're going to have lectures from Dr. Omer Ajazi on Kashmir, Professor Christian Laslett on Bougainville, and Dr. Randy Irwin on Western Sahara, as well as we'll hear from Dr. Hadil Abu Hussein on Palestine. So details of these other lectures we'll put in the chat. And Dr. Anna Saunders and Julia are also convening a reading group on the theme of making and unmaking our natural resources. So if you're interested, we'll put some more details in the chat as well.
I'm now really delighted to introduce our speaker for today. Michael Lynk is Professor Emeritus of Law at Western University in London, Ontario, in Canada. He joined the faculty in 1999 and has court courses in labour law, human rights, disability, constitutional and administrative law. He has written widely on the issues of Canadian labour law and human rights law. In March 2016, Professor Lynk was appointed by the United Nations Human Rights Council as the 7th Special Rapporteur for the human rights in the Palestinian Territories occupied since 1967. During his 6 years as Special Rapporteur, he regularly addressed the United Nations Human Rights Council in Geneva and the Third Committee of the United Nations General Assembly in New York. Professor Lynk's scholarship and his UN reports have been cited by the Supreme Court of Canada, the International Court of Justice, the International Criminal Court, and the United Nations General Assembly. He will speak for about 30 minutes and then we'll have time for questions. Thank you so much for agreeing to speak to us today. Professor Lynk, the floor is now yours.
For the introduction, and thank you so much for including me as part of your lecture series. This series aims to address difficult but important questions in international law and international relations, and I'm pleased that you've included Palestine and issues with respect to the Israeli occupation as part of this series. These are among the most taxing questions faced both in international relations, but as well in international law as well. It was a Canadian scholar who wrote perhaps 20 years ago, Jean Elan, who said that in the Middle East, international law is closer to power than it is to justice. And I think what I'm going to be talking to you today about with respect to the question of Palestinian natural resources and their exploitation by the occupying power Israel is a manifestation of that statement. So what I plan to do today is take you initially through issues with respect to the occupation itself, and also take you through the highlights of the International Court of Justice's advisory opinion from July 2024 and the resolution that was adopted welcoming it by the UN General Assembly in September 2024. And then I will turn to the specific question of natural resources under occupation and Israel's exploitation of Palestinian natural resources during the past 58 years. Next slide, please. So very briefly, this is what a map winds up looking like. You can see where Gaza is in the lower left-hand corner, and you can see how the West Bank has been divided up by Israel into what is approximately 165 separate disconnected islands of minimal authority by the Palestinian Authority based in Ramallah. There is no, to go from Nablus or Jenin in the north to Hebron or Bethlehem in the south would ordinarily take a car driver about 2 hours if there were no checkpoints, if there were no Palestinian-only secondary roads, if there were no separation apartheid wall with respect to it. But to go for a Palestinian to leave from the north to go to the south of the West Bank would actually take hours and hours if she or he is lucky enough not to be denied passage through any of these numerous checkpoints because they don't have the right color card or because their name is in a database. I won't go through, ordinarily, if we had longer, I would go through why we are in this particular situation, but I'm guessing that most of you probably have a good idea of what the start of the occupation in 1967 of East Jerusalem, the West Bank, and Gaza, and how after 1993, with the Oslo Accords, how the West Bank was divided up, with Israel now directly controlling 60%, the so-called Area C, and in fact really controls all that goes on between the river, the Jordan River, and the Mediterranean Sea. Next slide, please. I always want to stress when I talk about Israel and Palestine and this 58-year-old occupation that this is a highly, highly unequal struggle. In the 5 areas I'm going to tell you about, Israel is the dominant power in the first 4. Militarily, as you can see, it's a nuclear power with the strongest and best armed forces in the region. The Palestinians have homemade rockets, had homemade rockets in Gaza, and would have police issued weaponry in the West Bank. Economically, Israel has the same European style standard of living as countries like Italy, Portugal, or Spain would have. Its GDP per capita is now, in the aftermath of 2 years of this war in Gaza, is 26 times higher than the Palestinian standard. Territorially, Israel, as I said, is the overwhelmingly dominant political power between the Mediterranean Sea and the Jordan River. Diplomatically, the vast bulk of the global south winds up supporting Palestine. Most of them have had recent colonial histories. They view what's going on between Israel and Palestine through the lens of colonialism. But Israel has an unbreakable alliance with the United States and to a lesser degree with European powers. And that in current international politics counts for more than the strong support that Palestinians have in the global south. The only area where there is any kind of parity is in the population, where there are roughly 7.5 million Israeli Jews and 7.5 million Palestinian Arabs living between the river and the sea, with the Palestinian population actually gaining. That's probably now in a slight majority in that geographic area. I also want to stress, because I'm assuming I'm talking to an audience that's familiar with international law, how important public international law is to addressing and trying to resolve the question of Palestine. All of the answers that we need, quite frankly, with respect to why we could have the Palestinian Arabs and the Israeli Jews living together in prosperity, equality, and democracy, are anchored in international law and the hundreds of UN resolutions with respect to this. And that's why I'll be referring to primarily international humanitarian law today, but I would also be referring to international criminal law, essentially the 1998 Rome Statute, which created the International Criminal Court, and as well as international human rights law has a lot to say with respect to people's control and sovereignty over their natural resources. The importance of international law to the question of Israel and Palestine is that it would, if it was applied faithfully and exponentially to the question of Israel and Palestine, we would be much, much closer to finding a final, durable, and just resolution to the question of Israel and Palestine. Why? Because the rich body of international law and its values with respect to equality and human rights provide the guideway to having a just and lasting peace. It also has the benefit of having a strong, indeed overwhelming, international consensus on the content and application of the legal principles to Israel's occupation of Palestine. Yet, perhaps unsurprisingly, all of these principles of international law with respect to the right to self-determination, the right to human rights, the right to equality, the right to sovereignty over territory, the right to sovereignty over natural resources, and so on, have been strikingly absent from the Middle East peace process, beginning in the 1979 Camp David Agreement, to the 1993 Oslo process, to the 2003 Roadmap to Peace, to the Kerry Initiative in 2013, to the Trump Plan in 2020, and to this Trump Plan of 2025. International law has been steadily put aside in all of these agreements, and it's realpolitik, the power of the strong, that has prevailed instead. As I say in my last point there, the rule of law is meant to be a sturdy guardrail against the abuse of power. Its absence, and it's been strikingly absent in the question of Israel and Palestine, ensures that we'll probably have more bad agreements, and ensures also the lack of justice. Please go back one slide. Okay, so now go forward one slide. I think the wrong way. Sorry, yeah, I think we're going the wrong way. Right, okay, now I want to turn to the Israeli settlements, because they are a significant factor, both with respect to international law and the illegality of the occupation, but also with respect to the impact that the settlements have had with respect to the Palestinian lack of control over their natural resources. The settlements are the cornerstone of the Israeli occupation, of the cornerstone of Israeli apartheid, and they are profoundly illegal under international law. There's been a string of resolutions adopted by the United Nations Security Council with the support of the United States, which have come to that conclusion, the most recent of which in 2016 said that the Israeli settlements are a flagrant violation under international law. Next slide. The settlements are not only illegal, but they actually constitute a war crime under the 1998 Rome Statute. And Australia, like many countries, has actually incorporated the Rome Statute of the International Criminal Court into its own domestic law through the International Criminal Court Act of 2002. And in that act, it has a definition of war crimes. The war crimes definition includes the transfer, directly or indirectly, by the occupying power, in this case Israel, of parts of its own civilian population into the territory it occupies. Next slide. So this is actually the growth of the settler population. The whole purpose of Israel creating settlements and putting its own citizens into these settlements is to be able to establish an undeniable flag of sovereign claim over occupied territory, and also to create a domestic political constituency that, once it reaches a certain threshold, would be impossible for any government to want to remove in any attempt to try to have a two-state solution and the creation of a genuine Palestinian state. I've chosen these years here particularly to show you where there have been international agreements and how the growth of the Israeli settler population has continued unabated. In 1980, it was just after the Camp David Accords that had been negotiated under the leadership of President Jimmy Carter of the United States. At that time, you can see there were 12,500 settlers in the West Bank, and a total of 84,000 settlers altogether in the West Bank, East Jerusalem, and Gaza. In 1993, when the Oslo Accords were signed with the anticipation that there would be a Palestinian state created within 5 years. That figure of 84,000 are now grown by 3 times to 263,000, including 116,000 now in the West Bank. The whole point of the Oslo Accords signed in 1993 with the Declaration of Principles was to try to preserve land in East Jerusalem, the West Bank, and Gaza to preserve for the Palestinian state. Yet by the year 2000, when the second Camp David meetings took place to try to bring to a fruition what the wishes were in the Declaration of Principles from 1993, the settler movement had grown by another 110,000 settlers to 373,000 settlers. Now turn to 2013. And the reason I choose that date is because that was the year that then U.S. Secretary of State John Kerry announced he was going to attempt a peace process to try to bring a final resolution and a fulfillment of the promise in the Oslo Accords from 20 years before for a Palestinian state. And at that time, he said that, look, given the growth of the Israeli settlement enterprise and the fact that there are now almost 356,000 settlers in the West Bank and another 200,000 in East Jerusalem, we have only, John Kerry said, between 18 and 24 months to be able to keep the window open for a Palestinian state, or then it's all over and it's apartheid. So keep that in mind, because then in 2016, we have this resolution that I referred to earlier, Resolution 2334 by the UN Security Council, which said that, which condemned the settlements as being a flagrant violation of international law, and went on to say that the growth of the Israeli settlement enterprise was, and I'm quoting, dangerously imperiling the prospects of a two-state solution. And by that time, we had 400,000 settlers in the West Bank and another 218,000 in East Jerusalem, for a total of over 600,000. Now, the most recent figures coming from Peace Now and their Settlement Watch website say that in 2023, there were 738,000 settlers, including over 500,000 settlers in the West Bank. It's estimated now in 2025, there are around 540,000 settlers. Since the new Netanyahu government took power at the very end of December 2023, almost 3 years ago, there has been record numbers of settlers, particularly going to the West Bank. And the whole point, as the recent announcement was made both by Prime Minister Benjamin Netanyahu and the Finance Minister Bezalel Smotrich, who's also basically the Minister of Settlements, was the more settlers there are, the greater the impossibility of having a Palestinian state. The next point I want to make is that the Israeli occupation has been determined to be unlawful. Next slide. Since 1967, Israel has occupied the West Bank, East Jerusalem, and the Gaza Strip. And I'm going to assert that even though Gaza was formally evacuated of its settlements, its settlers, and its army, its boots on the ground 20 years ago in 2005, Israel has maintained effective control over the Gaza Strip, including who gets in and what gets in and who gets out and what gets out, which is the effective control test under international law. But occupation is governed by the Fourth Geneva Convention of 1949, earlier by the Hague Regulations of 1907 that I'll be referring to in a few minutes, by the 1977 protocols, and by various rulings coming from the International Court of Justice. And these are all of the central points with respect to how the law of occupation winds up pertaining to the Palestinians. They're protected people under the Fourth Geneva Convention. Occupations must always be temporary. When you think of what a classic occupation that follows the what would have been in the Fourth Geneva Convention, think of the Americans in Japan after the Second World War. That occupation lasted around 8 to 9 years. Think of the Western Allies occupying Western Germany after the Second World War. Again, somewhere in the range of 8 to 9 years before self-government was handed over to the Japanese and the Germans, respectively. The occupying power has absolutely no right to annex even a square centimeter or square inch of territory. They must govern in the best interests of the population under occupation. They must govern in good faith and follow international law and UN resolutions, which is the direction of the international community. And civilian settlements, as I said, are profoundly illegal. Next slide. So in December of 2022, the General Assembly of the United Nations asked for an advisory opinion from the International Court of Justice. The court is the highest ranking judicial body in our international legal architecture. There were 6 days of arguments in February 2024 in front of the court. I was there during those arguments. And then the court issued its advisory opinion in July of 2024, which had found that the occupation by Israel is now illegal under international law. And you see there their conclusion, which says that the sustained abuse by Israel of its position as an occupying power and its assertion of permanent control over the OPT, the Occupied Palestinian Territory, and the frustration of the Palestinian people's right to self-determination renders Israel's presence in the occupied Palestinian territory unlawful. Next slide. And then it went on to say that all states are under an obligation not to recognize as legal the situation arising from the unlawful presence of the state of Israel in the OPT, and that the United Nations has to, and particularly the General Assembly and the Security Council, have to consider ways in which to bring it to an end in the court's terms as rapidly as possible the unlawful presence of the state of Israel in the OPT. Then 2 months later, in September of 2024, the United Nations General Assembly voted overwhelmingly, as you can see, to welcome the advisory opinion of the ICJ. And you can see they actually added more definitive details. They said it demands that Israel brings to an end without delay its unlawful presence and do so no later than 12 months from the adoption of the present resolution. So now we've already passed the 12-month deadline. And this is now presenting, if you like, an existential question for the United Nations and how it's going to enforce international law and remove Israel from the occupied territories, East Jerusalem, the West Bank, and the Gaza Strip. And you see it demands that Israel immediately cease all new settlement activity and that it evacuates all of its settlers from the OPT, that it makes reparations, that it calls upon all states not to recognize as legal Israel's presence in the OPT, and strongly condemns the continued and total disregard and breaches by the government of Israel with respect to its obligations under the Charter of the United Nations, international law, and the relevant UN resolutions. You probably also know, I'll just make this as one concluding remark on that last slide, that there has been a second request for another advisory opinion by the UN General Assembly with respect to Israel's obligations in obeying its responsibilities and duties under the United Nations Charter, and particularly with its relationship with UNRWA, the UN agency that provides services to the Palestinian refugees, including the refugees in Gaza, the West Bank, and East Jerusalem. Keep your eyes open. I understand that that advisory opinion will be released by the International Court of Justice on the 22nd of October 2025, in 2 weeks' time. Okay, next slide. Now I'm going to turn specifically to what I've been asked to speak about, which is on natural resources under occupation and what international law says. So I'm not going to quote all of the law with respect to this, but I think you'll get a good idea of where the law is from the 3 or 4 segments of international law and international declarations that I'm going to quote. The heart of the obligations on a occupying power comes from the Hague Regulations, which were developed in 1907. And Article 55, as you see there, says that the occupying power shall be regarded only as the administrator and usufructuary of public buildings, real estate, and so on in the occupied territory. It must safeguard the capital of these properties and administer them in accordance with the rules of usufruct, which essentially means that an occupying, you think of what the of the Americans in Japan or the Western Allies in Germany after the Second World War, who were there during a lawful occupation. They were entitled to use, if you like, the water, or temporarily take over public buildings, or be able to use crops to be able to sustain its military and its occupation administrators during the time that the occupation was in effect. It was not allowed to go beyond that in terms of trying to exploit the natural resources of Germany or Japan in order to be able to use those for its own benefit and control beyond sustaining its occupying forces for the limited amount of time, the temporary amount of time that the occupation continues. And you can see the language winds up getting stronger in the next several slides. Here we have the Rio Declaration on Environment and Development from 1992, which says that the environment and natural resources of people under oppression, domination, and occupation shall be protected. And that, if you like, is the essence. And then we have a resolution passed last December, and this is an annual resolution that is adopted by the General Assembly with respect to Palestine. This language really hasn't changed much over the last 15 or 20 years that it's been endorsed every single year. And you can see where it reaffirms the principle of the permanent sovereignty of peoples under foreign occupation over their natural resources. And specifically with respect to the Palestinians, it says it reaffirms the inalienable rights of the Palestinian people over their natural resources, including land, water, and energy resources, demands that Israel, the occupying power, cease its exploitation, damage, loss, cause of loss or depletion, endangerment of the natural resources, and recognizes the right of the Palestinian people to claim restitution for its loss with respect to this. Next slide. Now let me take you back to the ICJ's advisory opinion from July of 2024 and what they said specifically with respect to Palestinian natural resources. So here in paragraph 124, it says and recalls the Article 55 of the Hague Regulations that I pointed out to you a few minutes ago, and it repeats what it says there. The occupying power shall be regarded, therefore, only as administrator and usufructuary of natural resources in the occupied territory. Therefore, the court ruled, the use by the occupying power, Israel, of natural resources must not exceed what is necessary for the purposes of the occupation. Next slide. With respect to water, the court said in a couple of its paragraphs in the decision that it noted that Israel placed the water resources of the OPT, particularly in the West Bank, under its military control in 1967. And then in 1982, it transferred authority of the water resources in the West Bank and East Jerusalem to the Israeli National Water Company, Mekorot. And there has been a series of UN reports that have looked at the question of water. And these reports have confirmed, and the court endorses these reports, that Israel prioritizes the water supply of its 360 plus settlements in East Jerusalem and the West Bank, to the detriment of Palestinian communities, which suffer from lengthy and frequent water outages. And then it goes on to say, Israel has imposed severe restrictions on the construction and maintenance by Palestinians of water installations without a military permit with regards to this. And then it says, in practice, Palestinians have little ability to ensure access to water in large parts of the West Bank. Instead, they must purchase significant quantities of water, must purchase their own water from Israel at a very high price. And if you just keep that slide there for a second, I just want to be able to point out that that there's been, in terms of estimates of water use, there's been a number of reports which have pointed out that the residents of Israel, which do benefit from water coming from the West Bank, and Israeli settlers consume approximately 3 times more water per person per day, 250 liters per day, than West Bank Palestinians, which have access and use of only about 84 liters a day. And according to B'Tselem, the Israeli human rights organization that does wonderful work on the occupation, they say that the Palestinians are currently extracting only about 75% of their share of water that was specified in the 1993 Oslo Accords, notwithstanding the fact that the Palestinian population in the West Bank has nearly doubled since 1995. It goes on, these reports go on to note, and I noted this in my own 2019 report on natural resources, that all Israeli settlements are linked up to the Mekorot national water system, and they receive developed world levels of water for drinking, sanitation, and commercial use. By contrast, the 180 Palestinian communities in Area C, which is entirely controlled in the West Bank by Israel, have no connection to a water network, leaving them either to rely upon shallow wells or to purchase water from tankers at a very high price. Okay, next slide. In terms of land, the court noted that from various UN reports, Israel's water and land policies have resulted in the reduction of agricultural land from approximately 2,400 square kilometers in the West Bank in 1980 to about 1,000 square kilometers in 2010, while the share of agriculture in the GDP of the occupied Palestinian Territory, it was 35% in 1972, 12% in 1995. Now, by 2020, it was less than 4%. Moreover, the court noted the expansion of settlements and industrial zones has contributed to the pollution of fresh water and groundwater in the West Bank, which means that this environmental degradation has severely undermined the Palestinian agricultural sector, reducing employment possibilities. In the Jordan Valley and the Dead Sea, this is area that's under obviously Israeli occupation. There is mineral-rich Jordan Valley, and also in the Dead Sea, that this now comes under the jurisdiction of all the regional councils in the Jordan Valley of the Israeli settlements, and they continue to extract minerals and cultivate fertile agricultural lands at the expense of the Palestinians. Indeed, you may want to sometime look at the kinds of creams or facial creams that you may want to buy at a drugstore or at a beauty shop, and determine whether or not some of those are coming from Israeli settlements in the West Bank using extracted Palestinian resources for this. And you can see there where it says, the court accepted that the UN Independent International Commission of Inquiry, Israel has granted mining concessions to Israeli operated quarries in Area C. The largest share of the raw materials that are extracted is transferred to Israel to build houses either in Israel or in the Israeli settlements. Israel, by contrast, has not issued quarrying permits for Israeli companies in Area C since 1994. And in terms of quarrying, I should point out that Israel has granted mining concessions to 10 Israeli-operated quarries in Area C of the West Bank, and approximately 94% of this production is shipped to Israel for construction and infrastructure purposes. And these make up an extraordinary loss in terms of monetary value to the Palestinians and the Palestinian Authority. And this was challenged in the Israeli courts by Yashdin, which is an anti-occupation Israeli human rights group. In 2011, they challenged the legality of Israeli quarrying operations before the Israeli Supreme Court. And in a ruling that reflects, I guess, the pattern of the Israeli High Court of Justice which provides judicial endorsement for many aspects of the illegal Israeli occupation, the High Court of Israel dismissed the petition, and they held that the Hague Regulations of 1907, in an extraordinary interpretation, provides for economic development and normal life under occupation, but it did so without distinguishing between the interests of the protected population, the Palestinians, and the legal prohibitions against economic exploitation by the occupying power. According to Michael Safard, who's an Israeli human rights lawyer, he said this particular ruling on the quarry cases, and he says, I'm quoting, transforms limitations on the powers of the occupying power to exploit the natural resources of an occupied territory into an authorization, a green light, to advance the very colonial enterprise that the Hague Regulations and the Geneva Conventions were set to try to eliminate. Okay. So the conclusion by the court was that Israel's use of the natural resources of the OPT is inconsistent with its obligations under international law. And it notes that a great deal of the interference with respect to this actually comes from the Israeli settlements and the Israeli settlers. And then it concludes that Israel's policy of exploitation of natural resources is inconsistent with its obligation to respect the Palestinian people's right to permanent sovereignty over natural resources. So very quickly, let me take you through what is the future, and then I'm happy to answer questions that you might have. Whenever I speak to audiences with respect to Israel and Palestine, I say, look, there are probably 6 possible futures for Israel and Palestine. The top 2 I have there would be consistent with international law and a rights-based approach. Either there'd be a genuine 2-state solution with an independent, viable Palestinian state on the pre-1967 borders, which would include East Jerusalem, the West Bank, and Gaza, and Israel within its pre-1967 borders. Or if that's not possible anymore, then one democratic binational state with equal rights for all. Those 2 would be consistent. The other possible solutions for Israel and Palestine, all of them are contrary to international law. The Trump plan from 2020 envisaged a tiny little Bantustan for Palestinians in parts of the West Bank and in the Gaza, which I call the state and a half solution. You could have one on equal state, which is annexation without rights, which is where some members of the Benjamin Netanyahu governing coalition are pushing Benjamin Netanyahu to declare annexation over most, if not all, of the West Bank. And this would be full-blown, so obvious apartheid. Or you could just continue with the status quo if Donald Trump keeps his word that he wouldn't allow Israel to annex the West Bank. Well, Israel continuing to manage the occupation by continuing to put 25,000 more settlers per year into the settlements, by continuing to build more and more settlers there, and ineffectively amounting to a de facto annexation. Or the last of the 6 possibilities is actually the expulsion of the Palestinians, which seemed to be for a while on the cards for the 2.2 million Palestinians in Gaza by the musings of Donald Trump and the support for that by Benjamin Netanyahu. So what does the international community, this is my last slide, have to wind up doing? Well, obviously, based on the ruling, the advisory opinion from the International Court of Justice by the resolution adopted by the General Assembly last September 2024, fully end the unlawful occupation, the removal of all of the 360 or more illegal Israeli settlements. There has to be accountability with respect to the genocide that's occurred over the past 2 years in Gaza, and for the grave breaches of international law by the Hamas leaders as well, as to what happened 2 years ago tomorrow, or 2 years ago today, I guess, in Australia, including genocide and genocidal incitement. Support genuine Palestinian self-determination, be that in a 1-state solution or a 2-state solution. Support and defend the work of the International Court of Justice and the International Criminal Court. Overturn Israel's ban on UNRWA working in the occupied Palestinian territory. And that may be, I think, one of the directions by the International Court of Justice in the advisory opinion it will be releasing in 2 weeks' time. Obviously, dismantle Israeli military courts, release all arbitrarily detained Palestinians, and a permanent ceasefire in Gaza, and ensure that the rehabilitation of Gaza is decided by Palestinians. In other words, nothing about us without us. That's my slideshow, and I'm more than happy to try to take questions from any of you.
Thank you so much, Michael, for that really comprehensive and incredible presentation, and for all your work and advocacy on these issues over such a long period of time. If anyone has a question, please either raise your hand or write it in the chat. I'll just use the chair's prerogative to get us started. One of the things that really struck me in reading the advisory opinion was sort of the absence of discussion about the corporations who are profiting from the plunder of Palestinian natural resources. And so I was just wondering, particularly given the current Special Rapporteur's recent report, Francesco Albanese's report about the economy of genocide and the role of corporations in profiting from occupation and genocide. Whether you sort of see some sort of way in which natural resources and the companies that are profiting from this plunder could be a strategic point of resistance to push back against this manifest illegality that you've described so powerfully. Thank you.
Great question, Julia. And this really is going to be a test of international law over the next 2 to 5 years with respect to the direction for Palestine and Israel. One of which is, as you've raised, is what happens to all of the extraordinary losses by by the Palestinians with respect to their natural resources, going to the quarrying, going to the loss of land, going to something I didn't mention, which is the oil reserves and gas reserves off Gaza, and of which there's been some recent reports which are very valuable in trying to block Israel from awarding exploration zones, particularly to Italian gas companies in the area that would be part of the marine territory of Gaza and Palestine. Francesca raises very good points with respect to the responsibility of companies with respect to the profits they've been making off the occupation. What this really means is probably this may be a bridge too far for the International Court of Justice and the International Criminal Court, though I suspect the International Criminal Court is going to take a while to be able to gather itself with in terms of its actions against Israeli leaders and Hamas leaders. It may be a long time down the road before they would turn their attention to companies. But then the question becomes, for all those companies, all those countries and states, the Australias of this world, the Canadas of this world, that have actually adopted the Rome Statute of 1998 into their domestic legislation, why can't there be domestic lawsuits brought against companies domiciled in the Australias or Canadas of this world with respect to compensation and restoration of losses for that? We could be on the cusp, as we thought we were 20 years ago, 25 years ago when the ICC was created, and all of these global North countries were enacting the Rome Statute into the domestic legislation. It's become a great disappointment that they've become largely dead letters in our legislation. And yet, I think what it needs is probably the creativity of lawyers who understand human rights, who understand international law, who have got a grounding in international criminal law, and can both use the courts and use popular opinion to be able to push forward cases within their own countries that would hold companies domiciled in those countries to account for the pillage, if you like, that they've committed with respect to Palestinian territory and resources. I think I saw it. Was it Natina? Did I see you put a hand up for a question?
I did. Thank you so much, Professor Lynk. So I have a question about the application or not of the IHL provisions that you mentioned, right? The Hague regulations, the Geneva Convention, etc. Because in a sense, they give quite extensive authority to the occupying power to exploit the resources, but of course for certain purpose, etc. And in a sense, my question was, can we say after July 2024, and especially after September 2025, that Israel has any of this authority? Do the provisions apply if the occupation has been said to be unlawful, right? Because then you have a contradiction in which you have the ICJ saying it's unlawful, but IHL authorizing the use of Palestinian resources partly for its continuation, right? Because it says, for the purpose of, to me, it sounds that the consistent opinion would be no, Israel can exploit no resources for any purpose, regardless of what IHL says.
Yeah. So let's keep in mind that when the ICJ issued its advisory opinion in July 2024, what it confirmed is what some of us were saying, that the occupation itself is illegal. But even before then, most of the world accepted that whether or not the occupation was illegal, and most countries in the North didn't accept that, there were aspects of the occupation that were deemed to be illegal. Obviously, the settlements were illegal. The exploitation of natural resources had been found to be illegal through resolutions coming from the General Assembly and from the Security Council as well. So even though there was an important timestamp put by the July 2024 advisory opinion, the illegality and therefore the right to claim restitution goes back a long ways before then. As soon as the first illegal moves by Israel with respect to the occupation, which occurred very early, they already began the very first settlements, civilian settlements, under the guise of establishing military camps in the summer of 1967. So I think, sort of going forward, your point is excellent with regards to this. So it's not only the fact that Australia, for example, has incorporated the Rome Statute into its domestic legislation. I'm assuming that Australia has also done what most countries in the global north have done and incorporated the Geneva Conventions and the 1977 protocols additional to the Geneva Conventions into your domestic legislation as well. So you have, if you like, the corpus of law to be able to go after, if, for example, an Australian company that would have profited by this, even before the designation of the occupation as being unlawful, because the aspects of how Israel was conducting its occupation and pillaging the natural resources was unlawful long before then. So, you've raised a great question, Nantina, with regards to this, and it just makes me think that all it needs is the creativity of good lawyers and the openness of judges to realizing that that international law is an important aspect of domestic law. We have a ruling in 2020 from our Supreme Court in Canada, which said that customary international law is a part of Canadian domestic law. And in fact, so we have the basis for being able to assert these rights in Canada if we can find the right fact situation. And we have lawyers now who are thinking of doing that. And I hope that the same kind of ambition is being shown by lawyers in Australia as well.
Yeah, one of the challenges, unfortunately, the criminal law provisions in Australia is that when they incorporated their own statute into domestic law, they also meant that you had to have permission from the Attorney General to bring a prosecution under those provisions. That has really curtailed ability to bring charges of genocide, even though a number of Indigenous activists have tried to bring those charges about ongoing settler colonialism in Australia, as well as also incitement to genocide by some statements made by Australian spokespeople for Israel on Australian television. But that's there've been these procedural barriers, so it really does require a lot of really creative lawyering to get around.
It does. My thought is, you and I are both products of the English common law system. As I would have thought we have the same filter of having to get permission from the federal attorney general to bring a case under the prosecution under the Rome Statute incorporation in Canada. What struck me is that if the attorney general denied it and would give, I think, probably fairly thin political reasons as to why, then I think, what is wrong with trying to bring, if we have the money, an application for mandamus to be able to force, the courts to say your reasons don't stand up, Attorney General, for why you're filtering the refusal of this case for prosecution.
Yeah. So I've got a couple of comments in the chat. Adil Hassan Khan's written, excellent talk. What is the pertinence of the right of return to this issue? And Erin Buckley has just asked for the name of the case, and I assume that was referring to the Canadian case you mentioned about customary international law, so that we can look that up and use it for advocacy here as
Tell you
well.
what I'll do. I will send an email to Caitlin and Sahiba and you, Julia, right after we finish with the citation and the link to the 2020 decision by the Supreme Court of Canada. It's actually a very interesting case because it involves the rights of Eritrean miners who were forcibly conscripted to work for a Canadian mining company as part of their military service in Eritrea. It concerned their right to be able to sue the Canadian company in the courts of British Columbia. The lower court said you don't have any right. It went to the Supreme Court. of Canada, and in a really monumental decision, which I'm happy to share with you. It's said that they do have rights under customary international law, and that customary international law is a part of Canadian domestic law as well. So if I can play the tiniest of roles in wanting to spread this good law from Canada to Australia, I'd be happy to accept that honor with respect to this. So, excellent talk. What is the pertinence of the right of return to this issue? The right of return, in one sense, is separate from this issue, but it all comes down to the same body of international law that applies to Israel and Palestine. Keep this in mind. There is no conflict, whatever you want to call it. No, there's no crisis, human rights crisis in the modern world where international law has spoken so consistently, so loudly, and so regularly with respect to the rights of a people, as it has with respect to the rights of Palestinians, both through international courts and through UN Security Council, General Assembly, and Human Rights Council resolutions, as it has with respect to the Palestinians, but virtually to no avail whatsoever, which is why I say when we talk about international law, particularly international human rights law, it is always a struggle between law in the service of power and law in the service of justice. And another great example of that is the Palestinian right to return. Some of you will know that that there was a very busy week in December 1948. In 3 successive days, on the 9th of December 1948, the UN General Assembly adopted the 1948 Convention on the Prevention and Punishment of Genocide. The following day, on the 10th of December 1948, the UN General Assembly adopted the Universal Declaration of Human Rights. And on the 11th of December 1948, the same General Assembly adopted a resolution 194, which endorsed the right of Palestinians to return to their homes and their homeland. Resolution 194, you may not know, is the most reaffirmed resolution, re-endorsed resolution in the history of the United Nations General Assembly. It's been reaffirmed virtually every year since then, and it's reaffirmed probably, I think, in 2 or 3 different resolutions each year and each December in the basket of resolutions that go through there. So with that constant reaffirmation by overwhelming majorities, it can be said to be part of international law that the 7, 8, 9 million Palestinians who are outside of Palestine would have a right to return to Palestine should they so choose, and whether or not that's returning to a Palestinian state, independent, or to a single state of Israeli Jews and Palestinian Arabs, the future will wind up determining. But they do have that right to return if they so wish, and that's an individual right that cannot be taken away by international law, cannot be taken away by an agreement of any sort with respect to this ongoing interminable peace process. So that's something that's powerful, that should be important to keep in mind with respect to how we regard the rights not only of the Palestinians who are under Israeli rule between the river and the sea, but the rights of those Palestinians outside of the river and the sea to be able to return as well. I think we probably I've got something else in a few minutes. I would have time for one more question, and then I'll send you the Canadian case a little bit later on this evening for me. So,
any final questions? Caitlin, did you have a question?
Yeah, sure. Thank you so much, Michael, for terrific talk. We've been thinking a bit about we were talking before the talk about the kind of insufficiency or the kind of limitations that states like Australia and Canada recently placed on their recognitions of a Palestinian state, but any kind of strategy that opens up from these declarations. Was there, I was wondering if you had any thoughts on the question of resources, particularly in relation to these recent declarations, or the question of recognition of statehood in particular. Thanks.
I think, this is something I briefly mentioned in the slideshow, is how international law has been steadily sidelined from any of the major declarations of peace or peace processes. And it's no accident that they've been sidelined, because international law does not favor Israel and its various claims over Palestinian territory or over Palestinian natural resources. I'm so pleased that you've asked me to speak about this, and I'm so pleased you made reference to my 2019 report to the United Nations with respect to this, because outside of an occasional report, actually there are steady reports with respect to the exploitation of Palestinian resources, but in terms of the broader issues of Palestinian rights, a right to self-determination, this often tends to be a secondary or tertiary issue that winds up getting discussed. It's not discussed enough with respect to what the Palestinian rights are for it, and with respect to the speed of and efficiency, if you like, of the Israeli exploitation of all of these resources. Israel is treating Palestinian land as its own. It's treating, obviously, the coastline, whether it's 10, 12 miles or 20 miles off the coast, as its own as well. And I suspect that it will, once, if there is a ceasefire. I was asked this morning on a television interview what I thought of what was going to be happening. I think there will be some sort of agreement that will at least allow for a temporary ceasefire, probably the exchange of Israeli hostages, living and dead, for a number of Palestinian detainees. I think one demand right now of Hamas is whether or not Mustafa Barghouti winds up getting released, which is something I think Israel would hate to want to wind up doing. I don't have any faith that beyond a few weeks or a few months that there will be any kind of agreement left in place. I would either think there's going to be a resumption of the war by Israel for some alleged breach by Hamas with respect to this, and there will be no pathway to a Palestinian state, I think. And this, the other thing I will say, and this, I'm drifting a little bit from your question, Caitlin, but I have to say, there's never been a time when I've been paying attention to the Middle East, which is over 40 years now, where I've thought that the Arab states in the region have been more irrelevant than they have now, in terms, if they can't break diplomatic relations with Israel after 2 years of a genocide in Gaza, then I don't know what it would take for them to forego that. And that probably has to do with the extraordinary agreements that they've reached with Israel, the gas agreement, $35 billion gas agreement that Egypt has with Israel, the agreements between the UAE and Israel. Who knows about any coming Saudi agreement? But there is no pathway to a Palestinian state that's on the horizon, notwithstanding the words that are in this agreement.
Thank you so much. That's a very somber and depressing note to end on, but I think an important message, and hopefully it spurs us on to keep working, to keep articulating the manifest illegality of this occupation, as we talked about, as lawyers, using our skills and creativity to sort of find different hooks to try and push for some form of, I guess, for law to try and dismantle this gross inequality of power that you started the talk by outlining. Thank you so much again for your time, particularly because I know the time difference is difficult, joining us in the evening in your time in Canada. And thank you everyone for attending and for the questions and discussion. The next lecture in the series will be Dr. Oman Ajiri talking to us about Kashmir. So we'll send the recording of this lecture and details of the next lecture to everyone who's registered, and we hope to see you there. Thank you very much, everyone.